Hello everyone and welcome to our webinar on testamentary trusts in practice, or to put it another way, practical aspects of testamentary trusts. For those that don't know me, my name is Adrian Bailey. I'm one of the principals here at Cleary Hall, work out of the Sydney office. If you've been to our webinars before, I will run you through, or you haven't, I'll run you through some of the aspects in terms of the practical aspects before I hand over to Brett. Brett and I were just chatting before we started, and he mentioned that he gave this exact same paper in 2002. So you can rest assured that there's at least 21 years of practical knowledge there about testamentary trusts. So hopefully everyone gets something from the webinar today. A little bit of housekeeping. You can download the slides from today by clicking on the Files button, which is over. It should be over on the right-hand side of your screen. If you click that, that'll give you a PDF version of the files. If for whatever reason you forget to do that, you want to have a look at the slides later on, no worries, just email us and we'll send you a copy. The webinar today will be recorded and will be put up on our YouTube channel later. So again, if you have to step out halfway or something happens and you don't get to watch it all and you want to watch it for some reason another time, you can always have a look at that. That usually takes about a week before it's properly up on our website and YouTube channel. There's some editing and so forth that goes on in the background before it goes up there.
Hair and makeup.
Yeah, a lot of photoshopping for you and I. So if you have questions today, just chuck them in. There should be a chat icon again over on the right-hand side of your screen. If you send through a question, I'll be on air but not talking, so I'll be able to monitor those and shoot them through to Brett as you see fit. Brett's more than happy for those questions to come through during the presentation, so don't worry about interrupting him. We'll also have time at the end for any questions that pop up then. So I'm going to hand over to Brett. Brett's been a mainstay of Cleary Hall for 30 odd years now. I hope you don't mind me saying that. Brett works predominantly in the estate planning area and the commercial area of the firm, so has a lot of knowledge in this area. And he's going to talk through testamentary trusts in practice.
Thanks, Adrian, and morning, everybody. Welcome to the forum. There's lots of papers written over the years on testamentary trust, mostly focused initially on the tax attributes of that, and then in more recent years, the asset protection side of things. As accountants, though, you are the ones who have to live with some of these things, and the administration of them and how they might work in practice is something we get a lot of questions about. So before we get into those bits, and that's about 3/4 of the paper, I might have to go through just a little bit of positioning and theory. So why would someone have a testamentary trust or think about having a testamentary trust, or a few of them in their estate, in their wills, usually? The first reason, of course, is asset protection, but it is all about the why. Why do this? And reaching back to some of those earlier papers we've written about this, I found one from a long time ago. In fact, this one was from the 90s, where our version of testamentary trust was born in far north Queensland, and in fact in the Burdekin River area, where we were needing to talk to cane growers about estate planning and about protection of assets in the next generation, and we were having trouble getting their attention on this electric topic. So John Hoare, who was then owner of Cleary Hall, came up with one slide with 2 questions on it, and I'll read them to you because I think you can understand why this might get people's attention in it and get them thinking about the why use testamentary trust for asset protection. The 2 questions were: 1, after you've died, just think about the next person who sleeps with your spouse could walk away with half your estate. That's the first question. The second question is, just think that after you both died, so mum and dad, someone who sleeps with your child could walk away with your child's inheritance. That's pretty blunt. Probably not as politically correct these days as it was in the late 90s, but that's what motivates people. That's their why. They're worried about what happens to their assets in the next generation or when they've passed away. It can go to ruling from the grave. That's a personal choice, but asset protection doesn't have to go that far. So they will do that because they have complex family scenarios in rural clients. Obviously, there are some succession issues there which are peculiar to primary production, but blended families or relationships within families or lack of them can motivate people to look at, well, what happens to these assets? I don't want them to be wasted. I want them to land with the people I intend to in a safe and structured way. Having said that, it's not all about protecting your assets for bloodline. And I've had a meeting, I remember distinctly up in the Kimberley many years ago, where we were talking about bloodline trusts with some graziers. I couldn't work out why they weren't really clicking with it. And at one point I was pulled aside and it was explained to me that mate, a lady who comes up here is prepared to work with us up here, can have whatever she wants. So we're not interested in bloodline. And so some families will be focused on protection of assets in the next generation, and some won't. And there's no right or wrong answer there. The other reason for a testamentary trust, which in our practice isn't very common, but a few times a year we'll be asked to prepare a trust in someone's will that might have a very specific charitable or even business or property-based purpose, or it may even just be for general benevolent purposes. So people don't do this just because it's on a checklist. They do it because they're motivated to, and why they're wanting to do it generally is asset protection. So we need to set some basics about what is a testamentary trust, and as accountants and financial advisors, most of you will have dealt with estates. So let's look at it in that context. So first of all, a trust is not an entity. You might regard it as an entity, and we talk about a trust as though it's an entity because you put in a tax return for it. But as a matter of law, it's not an entity at all. So you couldn't have the Bret Hart Trust sitting beside me here as Bret Hart the individual. That's just not the way the law is. What a trust is, though, is it's a relationship between, it's got three ingredients. First, you need a trustee. Then you need trust property. That doesn't mean real estate, but any property, $10 or a check, like settlement check. And the third element is at least one beneficiary who's different to the trustee. So you can't hold something in trust for yourself. That's not a trust. You need a distinction between the trustee and at least one beneficiary who's different to the trustee, so that there can be a fiduciary relationship between the trustee and the beneficiary. So those are the three ingredients, whether it's a discretionary trust or a simple estate or a fixed trust or whatever. In estate planning, when someone dies, you actually have a couple of trusts at least when you're using testamentary trust. The first one is when someone passes away at a particular date. You fast forward 6 months, after which there's either been a challenge to the will or things are going smoothly, and you move toward a more sedate administration type phase. And eventually you work out what the estate is and what it's comprised of and what its net position is. And at that point, usually the executors then change hats and become trustees. So they've administered the estate. It's taken a few months. And then they've decided they've done all that, and they need to go back to the will and work out where these assets go now. So from the date that person dies until the distribution of assets from the estate, that's a separate trust. It's a separate taxpayer, and almost all of you will have gone through the process of applying for a tax file number for an estate. It's not really a testamentary trust in the sort of testamentary trust we're talking about here, but it is a trust that was created under a last will and testament. Normally only goes for 1 or 2 years, hopefully not longer than that unless there's a dispute. We'll come back to, I guess, some of the other attributes, but if you look at what the next phase would be, and I said earlier there are two trusts generally in this scenario. First is the estate trust, and then in an estate where there are testamentary trusts as beneficiaries, that's a separate trust, and that's frequently a discretionary type trust. And I talked about those three ingredients, comprising a trust, same three ingredients. The trustee of the testamentary trust named under the will will be certain at that point. The trust property will be the right to call for the entitlements under the estate, and the beneficiaries will be the range of beneficiaries as they're described in the document constituting the testamentary, in effect, discretionary trust. The third point I'd like to address in this slide is what's the connection with discretionary and family trusts? Well, just being cautious about the notional estate rules, especially in New South Wales, which can drag some inter vivos or existing trust assets into an estate in the context of a family provision application. Leaving that aside, generally speaking, assets in existing trusts are not assets of the estate. So two things flow from that, and we'll spend a little bit of time on one of them, on control. That is, if those existing trusts don't form part of the estate, what happens to them when the trustee or the controller dies? And the answer generally is they continue on, but somebody's got to step into the role of perhaps director of the trustee company, or if it's an individual trustee, step in as trustees. or at the very least, if there's an appointer or a principal in those trusts, someone steps into that role. So it's about succession of control rather than, oh, someone's died, so we need to wind the trust up. That's generally not the case. One of the things that you need to be very careful of, though, is unpaid present entitlements. So whilst it might be true that the assets in the trust don't form part of the estate, therefore not available for distribution under the estate and not subject to estate disputes, that's a good thing. But grab the balance sheets and have a look at whether those discretionary trusts owe money, either as a UPE or a loan or in any other form, to the person who's passed away. Because whilst the assets in that existing trust are not estate assets generally, the link between the two can be jarring if there's a very large amount of money owed by that discretionary trust to the estate and if there's a dispute brewing in the estate. There's a question there from Mark.
Yeah, Brett, I was just going to jump in with that question for you. Is it okay if the director of the corporate trustee is an individual who's beneficiary of the trust?
Yeah, absolutely, it is. And remember those three ingredients: a trustee, trust property, and at least one beneficiary who's different. So a trustee in this example is a company, and a company is a legal person. So you could have a company called Bret Hart Proprietary Limited, and it's treated at law as a separate legal person. So in that example, yes, you do have the three ingredients lined up.
That's all for now.
So we'll get one more boring technical bit out of the way, and that is the taxation treatment of testamentary trusts. You probably all know that one of the motivators for clients in looking at this is, oh, well, you know, if I need to educate my children or grandchildren from after I've passed away, then if these testamentary trusts generate revenue or generate income, net profit, then I can allocate that net profit to young children, so children under the age of 18, but have them taxed at adult rates of tax, which in practice might mean 20 odd grand a year for each child or grandchild under 18 that could be used for that child's education or care or whatever. It doesn't mean you've got to give the money to them, and we've probably all read the Section 100A rulings in recent years, which have since been sidelined, about how you deal with allocation of income to children and so on. So that concept of having a friendly tax treatment for distributions to minor children or minor individuals is dealt with under Section 102AG. It deals with a range of other different trust concessions, but so far as trusts which have resulted from a will, and we'll come back to that, those trusts are captured under 102AG and provide us or provide the clients with some friendly tax treatment. But fundamentally, it's these testamentary type trusts are usually discretionary type trusts, so they're taxed under Division 6 of the 36 Act, but the outcome of what the tax rates are is distorted by Section 102AG. In terms of trustee resolutions, you treat them like any other kind of discretionary trust, and no doubt your accounting package checklist will prompt you to have trustee resolutions and so on. Some forms of these trusts are a bit more clunky in terms of trustee resolutions than a normal discretionary trust, so you'll have to read the deed. It's a catch cry we throw out there all the time. So just be conscious of that. But yeah, you will need normal trust resolutions like any other discretionary trust at the end of each financial year. So let's get into some of the administrative bits and queries that we frequently receive, and we've got a couple of slides here with probably 3 slides, about a dozen headings which we'll work through. So fire away questions as we go. So first point, about it's all about control. So one of the fundamental differences in this strategy of using testamentary trusts is that we're not talking about giving an asset to an individual. We're talking about giving that asset to an individual or a company as trustee, and then setting a whole range of rules about how that trustee deals with trust assets and income. So when we're talking to clients, we're actually usually not talking as much about, oh, well, if I give my car to Adrian, but if he's passed away, I give it to Carla, and then if she passed away, and you have the succession of this cascading gifting clause. The gifting clause is actually usually pretty simple. I give asset A or all my assets or whatever to the trustee of the XYZ testamentary trust under my will, full stop. But it is important, because these trusts are usually by nature totally discretionary. It is important to have the right trustees. And What that means for each family is different. Some will insist on having family members as trustees. Some will be quite the opposite, but many are in the middle. They'll have someone from the family as a trustee and perhaps an accountant or a sensible family friend as a co-trustee with a child and so on. And we can talk about that as in the case study toward the end of the paper. So it is about control. Appointing trustees and giving them the right restrictions and powers is important to making sure that from the testator's point of view, so from your client's point of view who's signing this sort of will, they have certainty in outcome, so they're not delegating their will-making power to give it all to someone else and you wake up your mind what to do with it. That is ineffective. And you could find that an angry beneficiary could have that type of will set aside for lack of certainty and for delegation of will-making power. So on the one hand, we want to be certain as to who the trustees are and be broad in the range of beneficiaries. On the other hand, we want to be sufficiently certain that the clients have comfort that the capital and income are going to go potentially to people they're happy with. Before I'll pull it up there for a minute, Mark's got another question about thoughts on an accountant being a trustee. I would say, Mark, about 80% of our clients would have their accountant as a co-trustee or an advisory trustee or in some capacity, even if it's for just a few years after someone's passed away. And even if your role might be restricted to, say, if they wanted to wind up the trust or they wanted to distribute capital from the trust or they wanted to change trustee, that outside party, that third party, often the accountant, would be the tiebreaker there. So definitely worth talking to the client about. Not all accountants or financial advisors are comfortable in that role. I caution against appointing lawyers of any kind as a co-trustee anywhere. If we were meant to know about money, we would have had different skills and we don't have them by and large. So I think it's best as a role for a sensible financial person rather than a lawyer and accountant falls squarely into that. The second thing I'd like to talk about is the certainty and making sure that we're not delegating our will-making powers. I've seen some examples of these sort of wills where they give everything to Adrian as trustee, and you decide who gets the benefit of the assets. That simply doesn't work and would be an invalid trust as an operation of law. The third point there, multiple trusts. If you have children in the family or beneficiaries in the family who are anywhere from their late teens or older, then usually we'll talk to the clients about having a separate trust for each of those children or beneficiaries, albeit that they may not succeed to control until both parents or grandparents or whatever have passed away, but we'd set that structure early. And that way the beneficiaries have some control over their own destiny because they're probably going to be a trustee alongside someone else or perhaps on their own. So multiple trusts, more often than not, will use that if there are children where the youngest is in their teens or older. Before I go on to the next one, I got another query there from Andy Miserolis. Andy asks, who should the appointer be for?
Sorry, Brett, to cut you off. Can you hear me okay? We can't hear you, so I'm not sure whether you've pressed your mute by accident. If you just want to have a look. You just started answering Andy's question. Top of the screen, there should be a microphone button. Just bear with us for a sec. We'll get Brett up and running again, hopefully. He's very good with technology. I heard he sent a Teams link to someone earlier today. In terms of the software, Brett, if the blue microphone at the top of the screen is highlighted, that's software is working. Be interested to hear what he said, Phil, if you can lip read. I think he might be calling in some outside support. In the interim, I guess I'll go back to Andy's question while Brett gets himself booted back up. A pointer for best protection in relation to family law. It's a good question, and currently one we're in, I guess you'd call hot dispute with for a client who's going through some family law issues. So family law will look at the trust as if it is, and the question will be whether it's property of the relationship. So in essence, they will be looking to see who is in control of that trust, and they will look at who the trustees are. They will also look at things like default beneficiaries. They'll potentially also look at, or not potentially, they will look at who is the appointer or the principal within that role. And where it is, for example, if you have a scenario where you have a testamentary trust set up for a child and they are the sole appointer of that trust, it's very likely that a valid argument will be made that that trust is just an alter ego of the child, because as the appointer, they can change the trustee to somebody else, usually under the appointer's provisions, and that's going to be fatal in terms of your family law argument. So if you wanted the best family law protection in that role, you'd be wanting to have the appointer being the child, because you'd still want them in there, plus somebody else. Who that other person is, I often say to clients, it's got to be somebody with common sense and with a bit of backbone, and someone who is willing at the end of the day to stand up in court and say, I just didn't rubber stamp decisions made by Brett. I made my own decisions. So it is an important role, important to consider. If we want to provide the best protection that we can, we need to look at that. Having said that, testamentary trust generally, as the law currently is and has been for a while, structured correctly, still provide a lot of that protection from family law, but best practice to have somebody else in there as well. I'm going to keep going while Brett's mute, or pretending to be mute anyway, to get out of doing the webinar. So first time we've managed to rope him in for a while, and as you can see, he's pulled a cord out somewhere halfway through, so he doesn't have to finish it. To be honest, I wasn't paying a lot of attention to the webinar, so I'm not quite sure where he's up to on this slide. I think multiple trusts. So yeah, effectively, in terms of those multiple trusts, the counter sort of arguments being you've got the simplicity of everything going to one trust as opposed to having multiple trusts with more flexibility. And usually, as you're dealing with clients who have adult children, they'll recognise that, and they'll want to have the multiple trusts and a share of the estate going to each. Distributions from other trusts in terms of the testamentary trusts. Yeah, usually you can make a distribution to the testamentary trust from other trusts. Income or capital, different scenario, and certainly we've seen the changes that went through in relation to 102 AG a couple of years ago. I've never been a big believer in the theory that you can distribute income from another trust to a testamentary trust, and that turns it into income of a testamentary trust. I would have always taken the view that it retains its character. Still no sound. And so that's certainly been tightened up in relation to those changes, which say in terms of the 102 AG treatment, then you will need to make sure it's only the assets or the income from the assets or replacement assets that have come through from the estate. Distributing to other trusts, again, as long as they fit within the definition of beneficiaries of the testamentary trust, no real issues in doing that. And by the same token, I would say that the flow-through treatment under 102 AG would still apply when that income goes elsewhere. Whatever the reason that you're doing it, distributing capital, on the other hand, I think it's pretty clear that we can't distribute capital from one trust to a testamentary trust, and for it to then, the income from that capital then to get concessionary tax treatment, that's not going to work in that sense. On to the next slide. I'll just jump in for some questions before we do. Another one from Andy: is it acceptable for the second appointed to be a brother or sister of the beneficiary? You sometimes see this. In terms of that approach, it's good and it's bad in my experience. the most recent most recent family court matter in this world, in terms of the issues in relation to that, you did have a situation where there was a brother appointed for the sister and vice versa. They tried to make the argument that that was just a sham, because they would just decide in essence for themselves. But that was found effective because of the bookkeeping of the clients in that circumstance. In terms of whether it's good, I say it's good and bad, because sometimes brothers and sisters fight. It's just part of life. So I often try to avoid it, but if it's the most appropriate thing and the brothers and sisters get on fine, then that's really it. And as Brett probably said, the thing that you'll spend the most time talking about with clients is who goes to these roles, because that's the most important part. Angela, do distributions from other trusts taint the testamentary trust? They don't taint it. They make it more difficult, because then you'll need to keep two separate books of account, or two separate, sections of the financials, one that deals with the original assets, one's with the new income. So it does make it more complex. Don't really see the utility in doing it, but some people may choose to do it. And a comment there from Raj that the ATO is giving him a hard time with accepted income. Well, come and see us, Raj, and see if we can give them a hard time back. In terms of administration of the testamentary trusts, one of the things that you do have to go along is get bank accounts. That's when you do want to kind of make the decision, if there's been individuals appointed as trustee, are they the right individuals? Do you want to appoint a new trustee, being a company, to that role? And Brett's back, and sounds like he's got audio there.
You hear me okay?
We can. I'm going to bow out then, Brett, and you're about to talk about bank accounts.
Okay. I've gone live, thrown away all the microphones, whatever, so just sitting in front of a computer. Thanks, Adrian, for babysitting, and sorry for that interruption. Bank accounts. Opening a bank account for a testamentary trust really, in practice, relies on someone having got probate, because the trusts are contained in somebody's last will and testament, and that's the trust deed normally. That is, when you go to open the account, there'll need to be multiple endorsed or certified copies of the probate document, which will contain the terms of the trust, and that's part of your bank pack in going to a bank. So we often will do a letter for the executor saying, this is what you tell the bank people, this is what the account should be called, here's the trust deed, here's the provisions in the deed which authorise opening of bank accounts, and so on. So mechanically, it's no different to opening an account for a discretionary trust. The second point there, governance. It's a really odd word, but what it really means, I think, in this scenario is two things. One is, how are decisions made by the trustees? Who votes, who doesn't vote? Are there restrictions on their powers to make decisions in certain areas? So decision making is part of governance, and being clear on what decisions can be made by the trustee and whether there are prohibitions, particularly, for example, of distribution of capital. If that happens, being careful to make sure that the beneficiaries, or the person receiving the capital, is in fact a beneficiary. The second part of governance is sharing of information. So how much information should a trustee share with beneficiaries? How much information are the beneficiaries entitled to? What level of communication should happen between trustees and beneficiaries, and sometimes among trustees? And setting those rules are really, for most people, part of, I guess, common sense. It's not often that there are detailed rules in a trust deed about that. You really have to just be aware of the general law and the rights and obligations of a trustee, and the rights and restricted rights of the beneficiary of a purely discretionary trust. The third element there in administration is variation. Remember, we talked about certainty for the testator. They do a will to make sure they know what's going to happen to their stuff when they die. What they don't want, generally, is the ability for someone later to change the rules so much that it looks nothing like the way they'd intended. So there's normally a variation power in the trust deed for the testamentary trust, but it's often restricted to address that objective of certainty by the testator, and so that it doesn't amount to a delegation of will-making power or leave open the possibility of a resettlement of the trust in a totally different direction to what the client had intended. But in implementing it, normally it's just a deed of variation just as you do with a family trust. Some longer term issues. Probably the first and the third point here, changing assets and replacing assets, is a pretty common question. Remembering that from a tax perspective, we've got a testamentary trust with the advantages of the concessions in 102 AG if it's a trust resulting from a will. So it's not about getting tax concessions only from income generated from assets gifted under a will. It's not that narrow. And Adrian spoke briefly when I was on the sideline about, whether distributions from ordinary discretionary trust to testamentary trust, whether they attract the same tax rate. And technically that question is whether that income forms part of the trust fund as a matter of trust law of the testamentary trust. And if it does, then perhaps 102 AG can help, but more often than not, it doesn't help and doesn't apply. So it's okay to change assets, provided there are powers in the trust deed to allow that to happen, the power to sell assets, to mortgage, to subdivide, to buy new assets, whatever it is. Looking at those specific powers is important. And replacing assets is okay too, and the normal governance rules would apply. Resolutions, if you've got more than one trustee, to evidence the capacity in which the person or the company is entering a contract or selling an asset, and just the normal housekeeping that would go with the trustee of a discretionary trust. Borrowing, there are usually borrowing powers in testamentary trusts. There are in ours. They are restricted. The idea again is to, when you're acting for the testator, to make sure that the trustees are not able to gear up to Billy-O and put trust assets at fundamental risk, but there needs to be borrowing powers, and normally they're a bit more restrictive than you'd find in a discretionary trust. Thanks, Peter Woods. Sounds all good. The last point on this slide, changing trustee. There's no real consistent approach to this across draftsmen. For us, we will be very detailed in who the trustees are when the testator dies, and we'll have a succession of people stepping into that role over time, as we'll spend quite a bit of effort on that question with the client to give them comfort that they know who the trustee is going to be and when and what some of the rules are with that. But if there are no trustees left, then we would have in our deeds a backup. So it might be, for example, something like the executors of the estate of the last trustee to die can nominate a trustee of this testamentary trust. So it is important to make sure there's no, you don't run out of trustees, or then you have to rely on the Trust Act in each state. There's a question from Sugahato: what stops the trustee of a testamentary trust is selling the entire assets of the trust? The answer is that depends on the trustee. Generally none. So if the trustee decides that in the best interests of all beneficiaries, and that's their duty, their fiduciary duty to beneficiaries, if it's in the best interests of all beneficiaries that assets are sold, then usually the trustee is entitled to do that. Of course, the money goes into the trust, doesn't go to the trustee, but that usually is power to do that. And another question from Wayne Kirkhope: doesn't borrowing taint the trust and eliminate accepted income? No, borrowing is not a component of whether you get accepted income or not, but it simply goes to those criteria in 102 AG. And is it a trust that resulted from a will? Is the income we're dealing with actually net income of that trust? And if it is, the treatment can be dealt with under 102 AG. I think probably borrowing is probably more of an asset protection and governance risk than a tax risk, I'd have thought. They do have a different view on that, but that's my 10 cents worth there.
No, I mean, not in the first instance, it's not going to taint it. And I guess one of the questions is, do we really want the 102 AG income? Like, it's, without getting stoned through the computer monitors, it's great from an accounting perspective, but 99% of my clients do this for asset protection.
Yeah, it's true, Adrian. I know I rarely see distributions in practice to minor beneficiaries. I guess, though, that's not that complicated, so it might be happening a lot more than we see in the offices of the accountants and tax agents. All right. Let's look at a short case study. And so at the beginning of the presentation, we talked about, well, why have a testamentary trust and what's the difference? And we talked about the main difference being a distinction between gifting assets to an individual and then gifting, or as opposed to gifting to a trust and looking at succession of control. So if Peter and Joan had 3 kids, and this is a will that would suit 98% of the Australian population, and they would probably say, oh, when one of us dies, the other one gets everything, then we're both gone, our children get it, say, in equal portions. If there's no concern about what happens to those assets in the hands of the children, then they don't need a testamentary trust type will, basically, no matter how much money they're worth. But if they're not concerned about asset protection among the children, then you know, the motivation to go to all the trouble to do a testamentary trust like will may not be there. On the other hand, we could achieve from an asset protection and succession and estate planning point of view an equal split of the estate, and making sure that the survivor of Peter and Joan control everything till they're both gone by using something like this. You'd say, well, when the first of them pass away, let's assume it's Peter, when Peter passes away, we are going to kick off 3 discretionary testamentary trusts. And of course, they'd be bloodline trusts in our world. And Joan's going to be the trustee of all 3 of those. Sometimes there'll be Joan plus an accountant if she needs some support there for the first couple of years after Peter's passed away, and vice versa. But probably only 50% of our clients do that. Normally, it's just mum or dad, the survivor of them, being the trustee when one of them passes away. Next most likely thing is that the survivor also changes their will, so you don't end up with, in their case, 6 testamentary trusts when they're both gone. But Peter passes away, Joan's the trustee of those 3 trusts, nothing changes for her. So she was in control of everything when Peter was alive together. Now she's in total control. No one else can tell her what to do. If she wants to allocate income to kids or grandkids, she can, but it's up to her. When they're both gone, this is where we put in, I would think, most of our effort in talking to clients about estate planning. Who are the next trustees? And the default position normally is, oh, well, it's each of the kids. And then about 80% of our clients choosing someone else to sit there with them. And in terms of opening bank accounts, some clients will open say there's only one property that's in the estate and it's owned 3 ways as tenants in common by the trust. They might just open one single partnership bank account that collects rent and pays expenses. If there are different properties going into different trusts, or the trustees of those trusts want their own bank accounts, and of course they can open those as well. There's a question here from Wayne Kirkhope. His scenario has got an operating testamentary trust that purchased a property which required a loan. He's getting conflicting information about the rental income not being accepted due to the loan. As Adrian and I talked about briefly, I can't see why the loan makes any difference at all. It's about whether the trust resulted from last will and testament, and about, to a lesser extent, where the assets came from. But happy to talk about that, Wayne, offline if you like. So you can see in this type of structure for an estate plan, testamentary trust can provide the same level of comfort for Peter and Joan that they would have had in a simple will, that they control everything, albeit they've got the ability to use those trusts sooner rather than later. And when they're both gone, probably the 3 kids would be trustee, or one would be trustee of each of their own trusts, and there would be a decision about whether all assets go 3 ways or whether particular assets go into particular trusts for particular people. So that's the conclusion of the paper on the practical aspects of testamentary trusts, but I'm happy to take more questions if we've missed any in the chat while I was sidelined.
Just while we're waiting, can I get you to turn your audio off just while we do a bit of housekeeping? Just while we're waiting for any questions to pop into the chat box, just chuck them in there. Housekeeping-wise, you will receive a feedback email from today if you could get the time to complete that. There's only 4 questions on it, 3 of which you just have to click a button, so it's not onerous in any way. But what it does do, and one of the questions is about presentations that you would like. So today's presentation was from a request from our last webinar. So if there are topics that you want to hear us talk about, make sure you chuck that in terms of In terms of those upcoming webinars, again, we'll be holding one towards the end of next month, and likely to be a topic that comes in as a request. A couple of questions coming through. Brett, I'm going to turn my audio off so you can jump back on and fire away as they continue to come through.
Okay, let's see, but I'll go to Andy Miserolis. Why use a bloodline option if a testamentary trust is an option? Andy, that's entirely a family matter, really. As I said earlier, not everyone sees the value in the bloodline approach, and they may want a more simple form or broader form of trust. So it's about picking horses for courses, I think. From Glenn Redgrove, please further explain the benefits of having multiple trusts rather than just one. Again, it's a family matter, so I'm one of 5. My father has passed away, as most of you know. He had no assets, so that didn't help us. But he did have a will, and it's more common than not that most children, given that many of them are going to be adults, will want control of their own destiny. At some point when mum and dad have passed away, if they've got a testamentary trust, they'll want to make their own decisions about their own investments sooner or later, and it's better to have generally that structure where there's a trust for each child or beneficiary, so that they can make those decisions later and uncouple from their siblings or whatever else if they want to. Edwina Johnson. Edwina actually used to work with us some years ago and been around us for a long time. Can remember John Hawes' presentations on this, which are a bit more blunt than mine. And yeah, that was a long time ago, late 90s, in fact. I think with the questions, I went through my Dorothy Dix list of questions, and I think we've covered them all, at least all the ones that I had 20 years ago and the ones that we were briefed with from feedback from our last webinar. So that's it from me, I think, Adrian.
We'll wrap it up. Thanks everyone for coming along, and hope to see you at the next webinar.